We'll hear from the appellant.
Tyler Chastain of the Knoxville Bar for the appellant, FF Property Holdings. I'd like to reserve 3 minutes for rebuttal, please, Your Honor.
That'll be fine.
Your Honor, we're here on a matter from the grant of a summary judgment by the Sevier County Chancery Court in favor of the plaintiff, Vincent Storms, represented by Mr. Hall. A judgment was rendered for $75,000 plus attorney fees of $9,674. We are seeking reversal of that, Your Honor. It is our position that the trial court improperly granted summary judgment in this matter. It's a breach of contract matter. We believe the facts at best are disputed, and that the trial court, in rendering the decision, did not give full effect to all the contractual provisions, and that and because of the way they interpreted the facts, actually resolved doubts of those facts in favor of the moving party as opposed to the non-moving party. There are certain things which are not disputed in this matter. One is that the declarations of Joe Fox of FF Property Holdings and Bart Franklin, the broker for FF Property Holdings, they were submitted in response to the motions for summary judgment. Mr. Fox and Mr. Franklin were not deposed. There was not any other countervailing testimony presented that shows that any of that testimony would be disputed. Would be disputed. We believe it's undisputed. There are several things that happened that the court simply did not accept, and because of the summary judgment standards, should have resolved those doubts in our favor and denied the motion for summary judgment. Now, I point out to the court the judgment that was entered by the court, which I obviously signed off on, also adopts and attaches the excerpt of proceedings. And I think that's very important, but the judgment itself says, and I think it's important to go to that, because this contract was basically found to be in breach because my client's FF Property Holdings, during a 30-day window after the contract was signed on January 19th, 2023, engaged in a process where they examined various financial issues provided by Mr. Storms, which was his rental income, the property itself. That right was provided in paragraph 8 of the purchase and sale agreement. Within that 30-day period, my client elected to terminate the agreement. I will address right up front the notification provision, which was the document submitted within the 30 days, has one provision that says it did not, I think it says I did not close because I didn't get financing. That's wrong, and if that was the only thing there, I wouldn't be standing here today. Paragraph 12 of that notification form complies with what is under paragraph 8, which allows them to do inspections and simply elect not to close the agreement. And that's what happened. This contract itself, under paragraph 2, which is in the record, talks about how the property is going to be purchased. My clients waived the financing contingency. This was going to be an all-cash offer. My client never sought financing. Under that same paragraph 2, it waived the appraisal contingency because it was not seeking financing. Those things are undisputed. But under paragraph 8, we have the right to do any type of inspection deemed necessary. Now, does that paragraph say does it limit you to only termite inspections or anything of like that nature? It references those things, but it doesn't say what type of inspections you can do. My client did an internal property review and analysis of this. They did not hire an appraiser. And that's important because in the trial court ruled from the bench, and the trial court said on page 6 of his opinion about this valuation that my client did. It says, well, all that is a valuation, and we call that report done by a third party a financial feasibility study, but it is in effect an appraisal. Now, I did call it it was a financial feasibility study. My client looked at everything necessary to determine if they were going to close. The record is undisputed that as part of that feasibility study that the septic system has significant issues. The septic system had a letter from April of 22 showing that it had not been approved by the Sevier County Department of Health, that the tanks needed to be replaced and repaired. I don't know about replaced, need to be repaired. My clients are going to purchase this property for the purpose of establishing Airbnb in Sevier County. They're going to have more people in this. Mr. Storms had 3 different Airbnbs as part of the property. The court, in making this statement, well, it wasn't done by a third party. It was done by Mr. Fox and Mr. Franklin as part for F&F Property Holdings. It was not an appraisal. There's not one appraisal in this file. There's no third party that testified they performed an appraisal, and my clients said we did an internal property evaluation of this property, and they came to the conclusion that it was not something that they could buy because of the additional cost, what they were going to have to expend, primarily in regards to the septic. As we pointed out in our paper, in our brief, we set forth Mr. Fox and Mr. Fox's declaration and that of Mr. Franklin about all the various issues that were associated with that septic system. We also talked about the fact they examined all the rents. Now, Mr. Storms knew that they were going to be doing this because he provided that information after closing as to rent so they could evaluate it. Now,
what in your contract allowed you to default based upon that examination?
Your Honor, under paragraph 8 of the contract, and I'll read that for you, Your Honor. It says, first of all, we elected not to do any repairs to that property or give him say you have to do repairs. But paragraph 8 gives the right to terminate that agreement within that 30-day period. Outside of 30 days, you couldn't do it. But inside of 30 days after the signing of the contract, you can examine it and you have the right to terminate the agreement. And if looking at in our documents,
For any reason?
for any reason, paragraph 8. A buyer's right to make inspections, all inspections report, including but not limited to home inspection report, those required in a home inspection report, et cetera, shall be done, et cetera. The parties then agree under paragraph D that has to be done within 30 days. And the buyer waives the option to request items to be repaired under D3, and the buyer retains the right to perform the inspections. But what's important is under E, this box was not checked. The buyer, having been advised of the benefits, waives any and all inspections, including any of these under Section 8. So my client did do those, but Section 8 would give them the right to make the inspections and then within that 30 days terminate the agreement, Your Honor. Outside of 30 days, they would have no right. The trial court deemed that an appraisal.
Mr. Chastain, let me ask you this. On the notice that your client submitted where it erroneously ticked the financial contingency box, did it also mention the issue with the septic system?
That they simply checked box number 12 on the notification form. They did not identify the septic system. That was discussed prior to the notice going out, but on the form itself, it simply has box 12 checked, but there's no reference to the septic system or anything else related to that piece of property.
Okay, and then assuming that what you're saying is the reason your clients decided not to move forward was because their financial feasibility analysis showed, in part because of the septic system, that it was not a good investment for them. Why would that not fall under any financial contingency under Section B that was waived?
Well, Your Honor, first of all, it's not a financial contingency. That's under the purchase price of whether they can get financing. The Tennessee in Moore versus Moore, which we cited in our paper, financial contingencies talks about the reasonable attempt to obtain financing for the purchase of property. Could the document, this MLS document, have it better defined? Maybe, but the financial contingency is under how the property would be purchased. Being an all-cash purchase, there was not a financial contingency that I have to obtain a loan, I have to seek financing. So we believe it's just a feasibility, and under Section 8, that would be the basis for which they could make that evaluation. And it would not be, and the appraisal is also under paragraph 2 of the contract, which talks about how I'm going to buy the property. The court clearly took the third party, took this internal and property report and says a third party did it, which is not under the record, and deemed it an appraisal. We believe the trial court erred because that's a determination of a fact as to whether it's an appraisal or an internal report. So that we believe that is that is a problem, Your Honor.
All right.
Yes, Your Honor.
So this is purely, what we're faced with on appeal is purely an interpretation of the contract. Is that right?
Interpretation of the contract, but also the consideration of the fact that there were other facts that the court did not examine as part of the summary judgment grant, which included that the fact that there was the third party, he calls it a third party report, was actually my client doing its own investigation of the property, and there was no reference to the issues regarding the septic in the court's opinion. But otherwise, Your Honor, that is correct. So we believe there are facts because the court does find that my client's own evaluation within the 30 days was deemed an appraisal, and that would be deemed waived under the appraisal contingency. If my client was relying upon a third party or a formal appraisal, Their formal appraisal was waived under Section 2C of the contract. That is not a dispute. We contend that that was not an appraiser. They were not an appraisers. They're not, neither Mr. Fox nor Mr. Franklin are appraisers.
Let me ask you that. I'm just kind of thinking bigger picture here. Like, this was for, I guess, a commercial purpose to operate Airbnbs, but I mean, it's the same language that you have in a residential, where you have financing contingencies and then you have inspection clauses. And generally, those are the only two ways that you can get your earnest money back under a contract for the sale of property, is if you can't get your financing or if you're not able to resolve an inspection issue. But I mean, imagine if we say that, we go with your argument and we say, okay, you determine it's not financially feasible, even if you have financing. So you don't fall under the financing contingency, you don't fall under anything. You could just back out because you've decided it doesn't make financial sense for you anymore. Shouldn't that be a decision just as a policy reason that's made on the front end before you enter into a binding agreement to buy a property for a certain amount?
In a perfect world, Your Honor, I believe so. But I believe paragraph 8D, which I believe gives the right for the inspection during that time frame, was contemplated that was going to be done, and that right would still exist. In a grand scheme overall, you would normally have all these inspections and have everything done before you're out of that period of time to have to close or not close. But in this situation, Your Honor, even if you take that, the paragraph 8D does give you a right to inspection. We believe the trial court, by overlooking the other things that are undisputed, resolved any disputes regarding what this appraisal was, what he says is appraisal versus a property report, in favor of the moving party, and that would simply be a basis for which summary judgment should not have been granted. The court should have given consideration of that, but when you read the order, that was not considered at all, Your Honor. I see that I'm out of time. Thank you, Your Honor.
Thank you. You have your time for, I'm sorry, here.
Just one question.
Yes, Your Honor.
So your premise is based upon paragraph 8D. That is what your appeal is based upon, is that correct?
Yes, Your Honor, and the language about not taking what we did during that period of time and not being an appraiser and not being appraisals. Yes, Your Honor.
Okay.
Thank you.
Here from the appellee.
Thank you, Your Honor. Scott Hall, on behalf of Mr. Storms, who was the seller of the property in this action. I note that overall, the buyers in this case, as we pointed out in the brief, are sophisticated buyers. They're all real estate brokers who formed an LLC, and that's who these buyers were. They're certainly familiar with the Tennessee Association of Realtor forms, which is the form that these buyers prepared and presented to Mr. Storms for consideration. The contract was entered, no question about that, and certainly the provisions that were cited by counsel are accurate in terms of this was a cash sale. There was financing contingency and any financial contingency, and that's an important distinction if we read the contract. Financial contingency is certainly different than just the phrase financing contingency. And if we look at paragraph 2 of the contract specifies that. It talks in terms of an appraisal, which was waived, and with regard to any financial contingency, the financial contingency paragraph talks about appraisal issues. So this issue about financial feasibility, which is the term that the buyers want to use to create a different, I guess, issue or standard, it is in fact an appraisal. It's looking at the property. What is it worth to me? What would it generate? What repairs potentially or might be necessary? But it's calculating values. It's calculating a return. It's an appraisal. It doesn't matter who it was from. But more importantly in this action, starting off with the notification. The notification is a requirement. And Judge McClarty asked with regard to paragraph 8, what do you do if there is a physical condition? If they walked out and they saw, well, there's a hole in the backyard that we didn't know was there, or there's a crack in the foundation that we filed. Well, paragraph 8 says you provide a notification and you specify what that item is that you are objecting to. And facts are perfectly clear. There's no dispute here. The allegations in the notification, as Judge Davis pointed out, specify unable to obtain financing, and number 2, they checked box 12, but they did not specify anything. They just checked a box. It didn't say because I don't like the color of the paint. It didn't say because now we hear the septic issue. It didn't say that. It didn't say anything. It didn't say the roof had a problem. There's a box in the blank. If we look at that notification form, which I'm sure the court has looked at, there's a box that can be filled in for identifying what the issue is that's being raised. Nothing was raised until we get to the point where we are today with regard to interpreting the contract and applying it to the facts. No notification of any objection with regard to any aspect of the contract, and the only thing that's being cited now is a financial feasibility determination, which I have argued in the brief, and I think it's clear it's a financial calculation. It's calculating numbers. What am I going to receive? What's the benefit to me? The contract states, quote, buyer's obligation to close shall not be subject to any financial contingency. Quote, this agreement is not contingent upon the appraised value either equaling or exceeding the agreed upon purchase price, unquote. Quote, financing contingency waived, unquote, and the parties agree to a cash offer. There's just no basis to set this aside. I felt like, I tried to be, I was brief with my brief because, as the court pointed out, it's a matter of interpretation of this contract. There's not a legal premise here that we're arguing about. It's that we studied in the contract books and such. It's just a matter of plain language of the contract. And I submit that there's no basis to overturn the court's ruling. The trial court was right. There is no notification of why there's an objection to entering this contract. The contract specifies, as it does, that under these circumstances, the buyers had an obligation to buy, and the damages that exist. We'd ask that the trial court's ruling be affirmed, and that additional attorney's fees that it be returned to the trial court for determination of attorney's fees, which is called for in the contract, unless the court has anything further.
Hearing none, thank you. Hear from the appellant, rebuttal.
Briefly, Your Honor, my clients are commercial in business of commercial real estate, just as Mr. Storms has been a commercial real estate broker for 20 years. They're both in the commercial real estate business. This is not, they're the same situation. I just think that looking at the facts and what was before the trial court, in the summary judgment standard, the trial court made a finding that he did not agree with what Mr. Fox and Mr. Franklin said, that this was not an appraisal. The court said he found that it was an appraisal. There were no other facts other than they said they did this. There's no other facts to support how he would rule in favor of that other than he took those facts in favor of the moving party versus the non-moving party. When the court reviews the record, it will see that they described what they did, they described how they evaluated, they described they did their inspections. The court said that was waived by the appraisal contingency waiver. I do not dispute there's an appraisal contingency waiver. I've never disputed that. We say that the court found that what they did and what they said they did, he went ahead and found that he just basically disagreed with it because there was no live testimony presented, no depositions taken. He just read their declarations and would say, I find that has to be an appraisal because it does various things. Mr. Hall and I have litigated this. I believe I'd like to go back and try it in Chancery Court as well, and I'd like the attorney fee set aside, and I'd like the judgment set aside, and it'll be reversed. And I appreciate your time if there's no more questions.
I hear none.
Thank you, Your Honor.
Thank you, both sides, for your briefs and your oral argument here. Recess court until 1:30 this afternoon, please.
All rise. This honorable court is now in recess until 1:30 this afternoon. Thank you.